Good morning, everyone. In the interests of my commitment to train a timetable like starting, welcome to session 5 of the Reconceptualizing International Law series, brought to you the 3 co-organizers of Independent International Legal Advocates, Gibson, Dunn and Crutcher LLP, and the TWILE seminar at UCLA Law School. For those of you who I haven't met before electronically, I'm Daniel Stewart, the founder and executive director of Independent International Legal Advocates, ILA. And this series is very much focused on bringing together, both from the panelists and then also from you, the audience, a range of international law and beyond actors from all different types of topics, as well as all different types of practices, academia, to really think about practical, concrete transformation to make international law the most effective or an effective tool, depending on your perspective, for the kind of just and fair, sustainable global society that we often set ourselves as a goal. As I said, this is session 5, sessions 1 through 4. We commenced this series in December of 2020. That seems like a lifetime ago. All of those topics covering not only our kickoff, talking about reparations and accountability for historical injustices, international human rights law and humanities law. Those 4 sessions you can find both on our website, both in terms of video and podcast form. So if you had the crazy decision to miss them, please don't do that and share widely. We'll have more sessions to come, and we'll advertise them in the same kind of ways, including reconceptualizing the sort of spaces of international law. I know we're all looking forward to working out what that actually means. I also want to thank, I should say, our co-sponsor, the Center of International Law at the National University of Singapore. Anyway, stay tuned for future. And let me hand over now to our moderators for this session from Gibson Dunn, Charlene Yim, and Mariam Kaloun. Charlene.
Hello, everyone, and thank you, Daniel, for the introduction. And thank you to all of our panelists and participants who are here to discuss this important topic. My name is Charlene Yim, counsel at Gibson Dunn, and I, along with my colleague at Gibson Dunn, Mariam Kaloun, are delighted to be co-organizers in this panel series and to facilitate today's discussion. When we talk about the colonization of international law, something we have discussed throughout this speaker series, international economic law is often at the foreground of the discussion. It has been criticized as reinforcing imbalances of rights that derive from its roots, and on the basis that many who study and practice in relevant fields do so without understanding the history of international economic law and the full scope of its repercussions. So today, we have put together an, if I may say, excellent panel of speakers to present their position on the history and development of international economic law, how international economic law is experienced throughout the world, and what we as teachers, students, and practitioners in this area can do, if anything, to reconceptualize its practice. Our first speaker is Professor James Gatti, Wing-Tat Lead Chair of International Law at Loyola University of Chicago School of Law. Our second speaker today is Professor Margot Solomon, Associate Professor of Law at the London School of Economics and Political Science. And last but certainly not least, our third speaker is Professor Fabio Morosini, Associate Professor at Federal University of Rio Grande do Sul School of Law. I should note that Ms. Mariam Al-Rashid, a partner at Eversheds Sutherland, where she is Global Co-Chair of International Arbitration, was scheduled to speak today, but she is unfortunately unavailable to participate. We will certainly miss her particular perspective as an international arbitration practitioner and hope to find ways during the roundtable and beyond to incorporate her views. So as with our prior panel sessions, each of our panelists will deliver a short presentation or opening remarks. Thereafter, we will have a roundtable discussion among the panelists to allow them to respond to questions from Mariam and I, from each other, and of course from you as the attendees. If you have any questions for one or more of the panelists during the course of their presentations, please feel free to input the question in the Q&A chat box available at the bottom of your Zoom screen. And we'll save all questions for the roundtable, We'll try our very best to raise as many of your questions as we can, time permitting. And with that, let's turn to the main event. Professor Gatti, I will hand the screen over to you for your opening remarks.
Thank you very much, Charlene, Miriam, Daniel, and all the organizers for inviting me to this conversation about reconceptualizing international economic law. In my opening remarks, I want to make one overriding point. I think we can all agree that international economic law may need reconceptualizing. I want to say, though, that my remarks are not merely or only inspired by the need to reconceptualize international economic law. Rather, I am convinced that we as scholars and practitioners of international law have the agency to reshape how we actually get to write and practice international economic law. That is, we have the power to exercise the privilege of shaping and reshaping international economic law in what we do on a day-to-day basis. We can agree, I believe, that international economic law, for the most part, has remained primarily preoccupied with highly abstract black letter law questions that obscure and shut out inquiries that do not fit within the four corners of international economic law. My remarks are aimed at urging us not to be passive practitioners or scholars of international economic law who safely work within the four corners of its assumptions. Instead, I want to suggest to you that, and perhaps challenge you, that as scholars and practitioners, our vocation should be to challenge the problematic assumptions upon which international economic law is founded, and to raise the types of issues central that are shut off from scholarly inquiries and in the practice of international economic law. In my view, international economic lawyers and scholars must take responsibility about how we write and practice international economic law in ways that push its boundaries and that match the political energy and momentum represented not just by the uprising against systemic racism, but also by innumerable grassroots struggles against neoliberal globalization around the world. To illustrate how we can do this, I will use one overriding example. This example comes from one of the most under-examined and yet very central aspects of international economic law, race. I want to suggest that we should do as much as we can to uncover how international economic law obscures its colonial and racist history and the legacy of this history to date. I will illustrate how we can do this by referring to examples of the ongoing legacies of racial oppression and disparity embedded within the rules and doctrines and practices of international economic law, and in fact, even in the racialized hierarchies of academia and practice. I think we can also agree that our ongoing moment of racial reckoning has not come from academics or politicians or practitioners of law, especially international economic lawyers. It has come instead from the political power unleashed by the massive grassroots protests against systemic racism and other things that touch on international economic law around the world. So resounding have these protests been that Gideon Rachman, the chief foreign affairs commentator of the Financial Times, argued on April 6, 2021 in the pages of the Financial Times that, I quote him, "The fact that 4 of the 5 permanent 5 of the United Nations Security Council are predominantly white countries arguably represents an international form of white privilege inherited from the age of empire. It looks," I continue to quote Gideon, "it looks unsustainable when roughly 5.8 billion of a global population of about 7.6 billion live in Asia and Africa." I end the quote. His article is titled, "Race is a Geopolitical Matter" in the Financial Times on April 6, 2021. It's on page 15 if you're interested. If a Financial Times journalist can make that point, I believe we, the practitioners and scholars of international law, can do even better. That is why I highly recommend, for example, among many others, Christopher Giver's article in the latest issue of the UCLA Law Review, Unwhitening the World, Rethinking Race and International Law. I think it's a much more profound analysis of the point that Gideon makes. What we need now more than ever before are more scholars, more practitioners to play their role in surfacing, interrupting the historical legacies of racial exclusions and racial silencing that pervade international economic law. Admittedly, overturning these legacies that have taken centuries to crystallize will not be as easy, as I'm sure we'll be hearing shortly from Professor Margot Salomon. Yet international scholars and practitioners can continually help move the ball forward by demonstrating the contingency of our current rules of international economic law. Our role should not be to reinforce what is all too often the effort to continually naturalize these rules as an inevitable set of arrangements. And we can do this, in my view, by probing these racialized underpinnings of international economic law and contesting and resisting them. There are many ways we could do this, but in my brief opening remarks, I want to give 5 examples of how international law scholars and practitioners can do this. First, I believe we need more analysis, contesting, and departing from the overwhelming dominance of representing rules of international law and international economic law as neutral, universal, and raceless. There are too few efforts that examine how rules of international economic law and the application have been and continue to be racialized for economic gain for some and not for others. We need more scholars and practitioners actively and openly discussing in practice, in scholarship, in courtrooms everywhere, how rules of international economic law produce, protect, and institutionalize certain advantages for some while denying them to others along racial and other lines. So there are many examples here one would give. For example, there are many ways in which there's already work that shows how many rules of international economic law are the vestiges of and the direct result of prior eras that benefited the former colonial countries, the white world at the expense of the non-white world, how elites in the non-white world have circled the wagons and captured the value produced and protected by rules of international economic law in the periphery. There are just so many examples of interesting work that I just don't see and which I believe should be done. If you think of the trade regime, for example, there's a colonial clause that's GATT Article 26.5a. There are many examples like that that I could give here. But I want to go to my second example. Second, there are many contemporary international economic law issues begging for analysis and scrutiny in terms of tracing historical continuities and discontinuities, especially relating to these questions of race and identity. Think about the racialized access to PPEs and the COVID-19 vaccines we are currently witnessing with the tragic and highly racialized consequences, both domestically, internationally, and in so many other ways. We have already seen some of this work in the scholarship of people like Professors Batiangi Salif and Ernesto Lopez Hernandez, but more scholarship of this nature that matches the activism of civil society movements and the grassroots needs to be done, showing the racial tropes that are being used to argue against equitable access to COVID-19 vaccines that are really the same types of tropes that were used and deployed during the HIV/AIDS crisis at the beginning of the 21st century by Big Pharma and governments of the global north. Nothing seems really to be changing. It seems that the lives of some, especially those in the global south, continue to be regarded as expendable and less worthy. And scholars of international economic law, in my view, must be involved in uncovering and debating these things, not just in abstract, dry international economic law terms, but in these more human, real terms. Third, another example is that we must have more scholarship that traces and uncovers the history of how international economic rules have been applied in ways that legitimate the extractivisms of minerals, fossil fuels, as well as agricultural, forestry, fisheries resources from the global south to the global north, especially in this time of the climate crisis. These extractivisms are today embedded in neoliberal globalization and have a direct links not just to colonial plunder, but to contemporary cases of corporate land grabbing, dispossession, exploitations, and we've seen how grassroots movements have emerged everywhere around the world to struggle against those realities. This kind of work, in my view, this kind of example, in my view, needs to be matched by scholarship and practice. Sort of matches what's going on in the real world. Twell Review has been publishing some of this type of scholarship, but more is needed. So fourth, we need more scholarship uncovering the strategies of covering up race or denying that race has anything to do with international economic law. My favorite example for all time is when the General Council of the World Bank marched into the United Nations General Assembly in 1969 to justify why the World Bank would continue lending to South Africa, to apartheid South Africa, and to Portugal, notwithstanding Portugal's continuation of its colonial policy in Africa after the end of colonial rule and the era of self-determination after the Second World War. I believe that there are many ways in which what we saw with that General Council continues to date in more ways that are subtle than the less subtle way that was invoked by the General Council of the World Bank in 1969, and we need to see more of that. Finally, and fifth, I think we need particularly practitioners who are not just experts in international economic law, but also in public international law, international human rights, indeed in critical analysis of law, including in such areas as law and society, critical race theory, and so on and so forth. So for example, I think practitioners need to read scholarship of scholars like Dina Tsuvala's most recent paper examining the von Pezzold case, titled, her paper is titled Invested in Whiteness, the von Pezzold Arbitration and the Question of Race in International Law, a really superb analysis of a claim brought by white farmers from Zimbabwe, and her analysis showing how the arbitral panel fenced off racialized harm from the past and narrowly focused on the claim in a decontextualized manner from the broader context of historical land dispossession, and ignoring how treaties such as the International Convention on Elimination of Racial Discrimination could have been used as an interpretive tool. This kind of scholarly analysis that I also believe practitioners are very capable of doing should be the kind of conversations that we should be having in international economic law. And we must firmly reject this public-private distinction that pervades a lot of discussions, both in scholarship and in practice. And to conclude, as you've seen from all my examples, you know, my goal here, my motivation is really very personal. Many have opened the doors for us to have these conversations that we are having today, and we must strive in respect of those that have done that to live our discipline or our practice much better, much different than we found it. Unless, of course, we accept international economic law as we found it is good and everything is good and nothing needs to change. So thank you very much.
Thank you very much, Professor Gatti, for your remarks. Over to you, Professor Solomon.
Hi, everyone. Good afternoon. Afternoon here where I am. And thank you very much also from me to our hosts and to my colleagues on the panel. This is a really welcome initiative, and I'm happy to be part of it. So I'm going to use my 10 minutes to make the case that international economic law can't be fixed in any fundamental sense, that if change is what we want, and I'm thinking about redressing poverty, inequality, the exploitation and alienation of people and nature, we're going to have to look elsewhere. The preconditions that define international law, and thus the particular interests that it favors, preclude major change. The result is that international economic law fails to meet the reasonable expectations of those whose lives are regulated by it. So what I want to start by doing is going back a few decades to 1992 in particular, and the work of the renowned social theorist Silvia Federici, in which she assessed the debt crisis in Africa. Federici narrates how the debt crisis and structural adjustment policies at the time, the infamous SAPs, made it, and I quote Federici, possible to destroy or neutralize the labor unions, to freeze wages, to pass laws making labor and other social struggles acts of economic sabotage, to end free healthcare and free education. And it's also resulted in the demise of local industry not connected to foreign capital. And most important, it has given the green light to the privatization of land. She demonstrates how the debt crisis, far from being an obstacle to capitalist development in the 1990s, was a productive crisis if seen from the perspective of the capitalist classes of both the debtor and creditor nations. So what Federici does here is she upends conventional lines of exploration in recognizing that what's at stake in the debt crisis is not, in fact, the repayment of debt, but the process that can be, or the processes that can be activated through it. Her trenchant account mirrors the handling of the 21st century debt crisis. The European debt and austerity crisis from 2009 was widely criticized on identical grounds. And it's well known that support for Greece from the Troika, the public creditors, the IMF, the EC, the ECB has been conditional on drastic reductions in public spending, in labor market reform, for which Greece has been held internationally responsible for violation of its social rights, but in fact, no international institutions, none of the creditor institutions have been. The other conditionalities included, drastic cuts to access to basic healthcare services, to medication, to outpatient pharmaceuticals, introduction in the healthcare sector of user fees that made it inaccessible to the poor, of course, undermine the infrastructure that we now rely on today during the pandemic. Privatization of the public sector was on the table as part of sort of a fundraising drive, quote unquote, and it included sectors, even though ultimately it didn't, and privatization didn't end up taking hold in the way that the creditors had hoped, but included water services and rail, gas and telecoms and motorways and electricity and so forth. We know by now that the human distress based on these conditionalities that were aimed to, quote, restore competitiveness and growth were enormous. Massive unemployment affecting the youth and women disproportionately, 50% by 2013, 58% unemployment, people living in incomes below the poverty line, 50% of people living below the poverty line at the time. We saw at the time also some sort of dramatic impacts, including a 200% rise in the incidence of HIV/AIDS and the return of mother-to-child transmission of HIV because routine screenings were no longer conducted on pregnant women, the return of malaria that hadn't been seen since the Second World War, and so forth. We jumped to 2018. We still see pretty dire figures. Unemployment remains in excess of 20%, youth employment in excess of 40%, and so on. Political economists writing on this have characterized the Greek economy as likely to be dominated by a small number of relatively large enterprises. Small and medium enterprises will continue to collapse, forever changing the pattern of ownership of capital in Greece, while unemployment and precarious employment and low incomes will characterize the lives of the majority. We move to our current day, under terms of COVID-19 official lending, alarm bells are ringing about crippling austerity, cuts to public services, greater privatization and worker precarity in debtor countries of the global south because of the borrowing that they'll need to address the COVID-19 crisis. I recommend in this regard the research done by Daniel Munavar at Eurodad. So this is a paradigmatic account of policy-induced poverty and inequality, the favoring of commodification to the benefit of foreign capital, and international law appears in every scene except where it doesn't. The protection of human rights, the right to health, adequate standard of living, the right to life, the rights to culture, and indeed the accountability of international institutions that are involved here. So we are overdue not only of taking international human rights law seriously, but in putting in place a comprehensive and influential and meaningful bottom-up system that, as some authors have written, makes people sovereign, right? Takes people's sovereignty seriously. So let's turn for a second to the law on foreign investment. So there's no shortage of awareness of the problems at stake, or certainly not among this panel and this audience. One of the demands that's on the table for reform of the discredited system of investor-state dispute settlement would be allowing for the site of justice to be nationalized through the use of the host state's domestic courts to resolve investment disputes, or new rules on exhaustion of local remedies prior to accessing investor-state dispute settlement. And my point for today is to highlight that this was the same argument made 50 years ago during the demands for a new international economic order, and a point, obviously, that capital exporting states won at the time. So importantly, in relative terms, reform of investor-state dispute settlement might represent an improvement, but it's still premised on a model of capital accumulation. It's premised on a model of exploitation of natural resources and exploitation of labor in periphery countries, and institutionalized collaboration with foreign capitals. These are not paradigm shifting demands that reconceptualize international economic law. So what are some of the other solutions, so-called, to the restlessness of the misery of the misery that international economic law has created? So here's a prominent example from international human rights law, that of the solution of the remedy of benefit sharing. So in 2018, the UN General Assembly adopted a declaration on the rights of peasants and other people working in rural areas. And the term peasants embraces and incorporates quite a large group of people, including indigenous peoples and others working the land and relying on the land. And this was a hard fought for declaration. Many peasant groups and the representatives of peasant community organizations represented and widely celebrated when it was adopted. And the declaration was meant to address and be a response to the impact of globalization on peasants and on other people working in rural areas, the impact on globalization and their attempts to salvage their relationship to land, to water, to nature, on which they were attached, on which they rely for their livelihood, and in many instances for their way of life and their culture. And the declaration articulates the claims of peasants given their commitment to, for example, small-scale agriculture, sustainable production, food sovereignty, agroecology. And there's some real novel rights that are represented within the declaration. The right to an adequate standard of living includes a facilitated access to the means of production, the right to develop community-based commercialization systems. There's a right to seeds, which includes the right of peasants to save and use and exchange and sell their farm-saved seeds or propagating materials. And this is, in order to address the commercialization of seeds by agri-food companies like Monsanto, Bayer, and so on, which has caused massive problems in the global south. But the declaration also requires, and I quote, modalities for the fair and equitable sharing of the benefits of exploitation that have been established on mutually agreed terms between those exploiting natural resources and the peasants and other people working in rural areas. And benefit sharing, this idea of benefit sharing is not unique to the declaration. We see it in a wide range of human rights and human rights law settings, and indeed in judgments of international human rights courts, also in terms of compensation. Through the technique of benefit sharing, the alienations and antagonisms that are produced by capital accumulation are merely managed, and the solution becomes an indispensable aspect of sustaining the process of capitalist exploitation and accumulation. And moreover, and this is sort of a central risk, the advocates of alternatives to the logic of private property, of exploitation, of accumulation are effectively silenced through the process of bringing them on board, bringing them into this model of benefit sharing that relies on exploitation and the distributions of the benefits that come from the current model. So if we're serious about reconceptualizing international economic law, what might this mean? I'm going to provide just one example from Ecuador, so some work that was done on Ecuador. So based on an ethnographic study of indigenous peoples from the southern highlands of Ecuador, and this work was undertaken by an anthropologist by the name of Erin Fitzhenry at the University of Melbourne, and an article she published recently, or maybe it's forthcoming, in the Journal of Human Rights and the Environment. And Dr. Fitzhenry highlights that the group's demands are not for shares of the wealth generated by mineral extraction, but shares in decision-making processes about alternatives to extraction. So even in Ecuador, she writes, that has explicitly underscored the importance of resource extraction to the expansion of a range of social rights and social welfare programs, and the promise to keep the profits nearer the communities that host these extractive projects. Affected communities are rejecting the distributive politics of the extractivist state altogether. In other words, in my words, reform is off the table, and there's a greater interest here in revolution, to draw on some sort of historical language in that regard. So to draw this sort of set of introductory remarks to a close, the fundamental problem, in my view, is that international law presupposes private property and the arrangements necessary to protect them and to profit from them. The existence of a commodity and money economy is the basic precondition, without which all the other concrete legal norms that we develop would have no meaning. So real change, real reconceptualization cannot happen on these terms. The poverty, the inequality, the ecological and environmental crises are not reflective of a failure of international economic law. It's what international economic law is structured to provide. And in my view, changes around the margins at this stage are simply not enough. Thank you.
Thank you, Professor Solomon. We look forward to exploring further in the roundtable. I'll hand the floor over now to Professor Morosini.
So good afternoon, everyone. Thank you, Daniel, Charlene, Miriam, and good afternoon to my fellow panelists. It was great hearing from you. I'll focus my introductory remarks on the investment regime, where you see there is a great connection to the previous interventions, and also to the issue of inequality and the role of international law in perpetuating it. So when I teach international law in Brazil, I do call the attention of students to the fact that international investment law is one of those disciplines where the colonial roots of international law is most visible. It is the story of a regime that is built with the sole purpose of protecting property rights of investors from a particular geography against the right to regulate of countries from another geography more to the south. It is the story where the most powerful wins and where the host states have all the duties and corporations all the rights. Some have qualified it as the perpetuation of colonialism through international law, but more recently others tend to qualify it as the pursuit and endurance of the neoliberal project through international law. It is, we have to say, an honest regime from the perspective of what it stands for and how it goes about achieving these goals. The regime is thus built upon a narrative of competition for capital and the need to accept the terms of the regime in order to attract this much needed capital for the developing world. So despite serious scholarly debate that challenges the centrality of the investment regulation, or at least the bilateral investment treaties, many countries in the global south still buy this narrative. They buy the narrative of competition, and they buy the narrative that they need investment agreements of this sort to attract this much needed capital. After all, foreign capital is very much important for their development projects if they are rightly channeled. So seen from this perspective, it's also a very perverse regime. I'll guide you, or I'll comment on some of the more pressing, seen as pressing and contemporary problems associated with the investment regime, and then I'll offer some concrete ideas on how some countries in the global south are going about either reconceptualizing or maybe reforming within the mandates of the global capitalist system. So after the initial enchantment with the regime, states and other actors discovered that in practice, international investment law may have much unwanted consequences. For one, it limits host countries' right to regulate, and then we have Philip Morris arbitration on and public health in Australia and Uruguay. Going back to Professor Gatti's point on racial inequalities and the past legacies of apartheid regime, we had the Foresti case that limited South Africa's ability to implement its racial policies. We have white industries and the interference in host countries' judiciaries in India, just to cite just a few more noticeable examples from case law and arbitration. More and even more, we have the impact of investment awards on host countries' finances. See, for example, the arbitration award on Occidental versus Ecuador, the 59 awards against Argentina, and the white industry versus India, mandating India to pay a $4 million award. So this regime also has a substantive impact on the finances of these global South countries. Also, a second pressing point about the flaws of the regime have been canalized in the discussion of concerning the realization that investor-state dispute settlement has so many flaws, and I'll just cite a few, but the lack of transparency, problems of repeat players, of arbitrators and counsels to arbitrations, and their consequent conflict of interest, the issue of bypassing local judiciaries, etc. And curiously, although the investment regime, in my opinion, has most of its flaws in how it's materially settled, materially organized, most of the discussion today at the global level is being channeled to discuss ways to reform ISDS, as if the material aspects of the regime were not necessary, were not to be changed first. So in light of these problems and how they affect particularly the interests of countries in the global south, a few years ago, I organized a research with a colleague, also another colleague from Brazil, with people or scholars from some countries in the global south that were undergoing changes or reconsidering how to approach international investment law in a way that is different from the traditional bilateral investment treaties. So in light of this situation, in light of the pressing needs that are brought about the way that currently investment law is regulated, especially in the context of bilateral investment treaties, options, they range from abandoning the system altogether or maybe abolishing it, or you can reform or reimagine the system. I understand that this process of reimagination, the process that I'm about to describe, may not be qualified as a complete reconceptualization, but also you have to take into account that even the strongest countries in the global south, they also have their limits in terms of leverage and changing the international system. So it needs more than just some countries in the global south to bring material changes. So we in this study, we focused at least in three countries. So we focused on the case of Brazil, India, and South Africa, and how recently they have been going about promoting changes that some scholars would qualify as a reconceptualization, but maybe it's more of a type of a reform that is more instrumental to the needs and demands of these countries. So materially, they have, for instance, redefined how investors are to be defined and who gets to define investors and investments. So against broad definitions of investment and investors, connecting to local laws, as the case of the Brazilian model agreement. The issue of how to reduce investor protections, because it's assumed and perceived that the type of regulation that we now have is overprotective of investors' rights. So there are new clauses qualifying national treatment, excluding most favorable nation, and also excluding in some cases the clause on fair and equitable treatment. Also, there is focused on direct expropriation, and some of these countries are excluding or at least limiting indirect expropriation. So this is some concrete examples of how these countries are going about introducing changes to the way that investment regulations are at least connected to these jurisdictions. Procedurally, the debate, of course, is concentrated on alternatives to ISDS. So, for instance, in the Brazilian case, Brazilian investment model does not recognize or doesn't accept investor-state dispute settlement, and it invested a lot of time and energy to develop a system on investment prevention. South Africa, as Professor Margaret Solomon has just mentioned, is one of those countries that is going back to the solutions of the 1960s and 70s, so going back to the national judiciary. And India, although it's accepting ISDS, is demanding exhaustion of local remedies. But beyond looking at these concrete examples of the global South, there are at least doing, in my perspective, what they can in terms of trying to address their more pressing needs in their engagement with the global economy. I think that still we need to look to other sides of investment regulation. I feel that the debate is too much focused on bilateral investment treaties when we look at the investment regime. And I think that there are investment law by other means that is just underexplored, and also underexplored from the perspective of critical approaches such as post-colonial international law. So I do feel that current debates about investment regime is too narrowly focused on BITs. And while I recognize that they are important and should be reformed, if not abolished, other important sides of inquiry in investment law are disregarded. This is what I like to call the investment law by other means, in the absence of, for instance, traditional trade agreements and investment tools, such as trade agreements and bilateral investment treaties. And one example coming from my recent empirical research with my colleague Michelle Sanchez is on the economic interactions between Brazil and Angola, or the interaction of Brazilian enterprises in Angola. And we, in this study, is one of those cases that Brazil and Angola do not have bilateral investment treaties. They do not have any type of trade agreement, but still the flow of investments and trade is very important, at least for Brazil. And then we went about trying to uncover what types of legal tools were employed by these two countries, and we found a plethora of different tools that are not considered within the mainstream international economic law field, that we feel that needs to be understood. Of course, this is a side of asymmetry, where Brazil is being the more economically powerful, but we are still not comfortable with the classification by some scholars in the global north that this is a new type of imperialism or new colonialism, that Brazil is just reproducing colonial practices in relation to Angola. I think the histories of these two countries deny this possibility, and also our empirical work shows that it's really the story about one important Brazilian corporation, Odebrecht, operated in Angola, but it also operates serving the interest of the Angolan elites. So I think that when we think about, I'm bringing this example much more as a provocation. I don't have any how can I put it, any pretension to be certain about this, but I do think that the post-colonial approaches to international law or approaching these types of South-South investment and trade agreements from a post-colonial approaches or from these lenses also need to be, I think the lenses need to be kind of like reorganize to better understand the type of dynamics from a critical standpoint. But this would be my initial thoughts on this very much interesting debate on how to reconceptualize investment international economic law. Thank you.
Thank you, Professor Morosini. So we're now going to move to our roundtable. I'll just bring our panelists back onto the screen. So thank you to all of our panelists for your initial remarks. I think you've given us a lot to think and talk about in this roundtable. I just want to remind the audience members that we do have the Q&A chat box in the Zoom. So if you have any questions that have come to mind, as you've heard our panelists give their initial remarks, please feel free to send those our way, and we'll try to feed them into the conversation. But if I could get us started with just a very general question to all of our panelists. You know, across all three of your presentations, you've brought up different stakeholders and actors that have or could have a role in this exercise of either reconceptualizing or, you know, perhaps replacing the system of international economic law. And so we would appreciate going a little bit deeper into that and asking you to let us know, you know, with whom and where do you think that this task really begins? And while it is simple to say that everyone should be involved in these efforts, who are really the necessary actors and the key components? And if you think that this system can't be reconceptualized, what is the alternative pathway that's available to us to continue trade or commerce in a different form? Perhaps I'll ask Professor Solomon to get us started.
Okay, that's a huge question, but I'll just kick us off with one or two remarks. So one is that, you know, what I was trying to suggest is that what would really be significant, and I'm now probably distinguishing between what's likely and what's possible and what's politically feasible, right, from what we want to think about when we want to think about sort of deeply unsettling the status quo. So we can maybe have a different conversation about, you know, what's politically viable in our current world and so forth, but I think that's a separate but related conversation. And I think what would be significant in terms of sort of rethinking the key components is merely to not have any assumptions about what the organizing principles are. So everything we've discussed so far, understandably, not everything we do, you know, many of the things on the table, I mean, we tend to start from where we are, and that's the whole nature of reform, right? We take what we have and we see how we can do it differently and do it better. And what I'm trying to open up, and I think both of my co-panelists have done the same in different ways, is to open up the possibility of doing away with the assumptions that have always underpinned international law and international economic law. So for me, that would be seminal, and linked to that, and that by that I mean sort of the right to private property and the idea of, you know, of contract and the whole, you know, the whole structure. I mean, there's a lot of work being done, and maybe I'll come back to this later. You know, there's a lot of very interesting scholarship emerging now on the commons, and the links to international law on the commons, less so, and some links to international human rights law and the commons. If you take a look at Michael Fakhri's first report as Special Rapporteur on the right to food, he's also thinking through ideas of solidarity. How do we meet each other as buyers and sellers? Could we meet each other differently? Do we have to meet each other through, and that was the point about my benefit sharing, is the best we can do to redistribute the means of exploitation, like the profits and so forth. So what's central here would be not to take for granted that the existing system is unmovable and unchangeable, and to take seriously the possibility of an entirely different system premised on different principles, on different ways of engaging with the land, and not on private property at all. So related to that, I guess, would be the question of, who takes part, and this is probably an unsatisfactory answer to that question, but along the lines of what I've been saying, it's all those affected by the law, right? What we've had so far is really an elite construction of these norms with some some assumption that there'll be a fallout, there'll be a byproduct of this model based on greed will effectively trickle down and benefit everybody, whether that's the global south or particular countries or indigenous peoples, right? That's still fundamentally the idea. And so people who are the lived reality of peoples and their experiences, they're the ones who should be making the law. They're the ones who have something to contribute and will be the ones to offer the real alternatives and to scale it up. So when we think about who's part of the conversation, make the people part of the conversation who have been on the sharp end of the existing model. Thanks.
Yeah, I mean, just to add to that, I think it's important to recognize there will be no high noon where we reconceptualize international economic law, and that, in my view, that's why I think it's important to take up the challenge that Professor Solomon is putting on the table, that we shouldn't be reifying the current arrangements as inevitable, as natural. But from my perspective, I think that all of us have a responsibility in the scholarship we produce, the advice we give clients, the advice we give governments in connecting to the massive movements that, like Professor Solomon suggested, face the sharp edges of international economic law, to surface those things, to disrupt the narratives that naturalize and make this inevitable. We need more case books that teach from a different perspective, and we need more honest conversations that are not just seeking profit, not just for the clients that are being advised in international economic law, but also for the practitioners. So for example, I think now it's a consensus. The UNCITRAL Working Group 3 process is not going to make any headway in terms of any substantive changes. In my view, what's likely to happen there is that the practitioners are making life better for themselves, and that's what's going to happen. And in the meantime, they're going to entrench all the negative aspects of the system that I think all three presentations alluded to. So while we can't say that there is going to be a turning point, we can't also say that nothing can be done.
Yes, I agree with my fellow panelists, and I think there is the challenge really is at the level of ideas, right? So it seems that there is this enduring presence of global capitalism, and then law is just an instrument for that project, and that's quite clear in the case of international economic law. So I do think that for us as scholars, I think we have a very important role to play in terms of demonstrating the power of ideas and how we can reimagine the system, even if even if global capitalism still is very present. I think there are some ways in which we can do that, and some people have been producing very good scholarship in this sense. And I'm thinking about the recent books by Nicolas Perroni, and also a new book by Professor Sergio Puig on the local communities and how these communities can be engaged in the process of rethinking international economic law. I think I would go further in terms of amplifying not only for local communities, but for other stakeholders, the civil society at large. Coming from the Global South, of course, I would love to have the Global South incorporated in the debates. Professor Gatti mentioned the entire discussion on the Working Group 3 on ISDS, on alternatives to ISDS. But I think I also think that the many leaders in the Global South, they also need to be decolonized in the way that they perceive international law and their role in international law, because it's really astonishing. I have been able to follow part of the negotiation process for Working Group 3. And coming from Latin America, where you see so many damage that have occurred to these communities, and you see that their negotiating authorities are still pushing for the same type of treaties and regimes, this is something that makes me very perplexed. So I do think that that the efforts are, as a professor here in Brazil, I consider myself a minority in terms of teaching international law from a more critical perspective, because the environment is very much pro establishment and what and how these countries can mostly follow the mainstream narrative. So I think there are great challenges, but I think education is our way out here.
Thank you. I think flowing from that, we've had an interesting question come in from one of our audience members who asks, do you think the inclusion of sustainable development provisions into investment agreements and free trade agreements is cynical in that it legitimizes those regimes? Or do you think that there is hope for affected communities' grievances to be better accounted for through those measures? And perhaps, Professor Morrison, I know this is something that you were discussing in your presentation as well. We could start with you.
Could you just please just repeat the question?
Of course.
Yeah.
Do you think the inclusion of sustainable development provisions into investment agreements and free trade agreements is cynical in that it legitimizes those regimes? Or do you think there is hope for affected communities' grievances to be better accounted for through those measures?
Mm-hmm. Great. Yeah, so this is a great question. Because when I did work on how some countries in the Global South were trying to bring new inputs to the debate, to the right to regulate, that's something that I give some thinking about. Because if you think about, okay, so my first response would be, I don't think that the way trade agreements and investment agreements deal with the claims for sustainability, and even think about climate change now, they're very present to our societies and future generations. I don't think that they do a good job, because I think that they tend to put environmental concerns or even other types of policy concerns in a very exceptional way to the regime. And I think that through reconceptualization needs to come from a new understanding of the economy that passes by the idea of a green economy, where these sustainability clauses, they cannot be exceptions to trade agreements, but they need to be at the core of trade and investment agreements. So unless we do that level of change, I don't think that the commitments as we have it now, both for trade and investment, do a good job. In addition to that, I do think that from a Global South perspective, or from someplace in the Global South, I don't plan to speak on behalf of the entire Global South, speaking from my condition as a Brazilian. I think that there are claims that go beyond sustainability that are not heard by this regime, and that are of particular interest to the Global South. So race being one of them. So why shouldn't we be allowed to include policies related to racial equality in investment agreements and make it part of the mainstream debate in terms of right to regulate? That would have, in my opinion, shaped the decision on the Foresti case in a very different way that it was finally concluded.
If I may just add, just very briefly, I think that the legacy of sustainable development being added to international economic law agreements had its very high point in the appellate body, one of the appellate body decisions, where the appellate body invoked sustainable development to construe an exception to allow the United States to invoke that exception to justify certain environmental measures. But we really haven't seen anything beyond that, in my view, that sort of would give us any evidence that the inclusion of all these principles, important principles, including the precautionary principle that is also highly contested in the WTO. I don't see any evidence that they made a dent, because they are added, they are layered on top of all the problematic regimes. And then, as Fabio has noted, sort of construed extremely narrowly. And, this is what pays the bills for all those big law firms that represent investors in ISDS proceedings and in the WTO, where they're arguing on sort of pages upon pages, paragraphs upon paragraphs, as to whether the exception should be invoked, and whether, if it should be invoked, for example, the WTO, whether it meets the other three conditions in the preambular provisions, the chapeau of Article 20. So I am highly skeptical. In the international investment regime, I think one of the major problems there is the way the regime allows investors to externalize all the environmental, human rights, and other consequences. That's just the design of the system, structurally designed in a way that I don't think it would be dented by principles such as sustainable development within the current system. So they are great principles for social movements, as Professor Margot Solomon was arguing, to mobilize, to organize, to resist, to protest, to have alternative ways in which they would like to have their relationship to land, territory, and culture organized, as the very important work of another person I'll mention, Arturo Escobar's work, for example, in Latin America shows. But we should not overestimate the importance of those principles. They're the kind of principles that make international lawyers salivate because of the complexity of the arguments, but that doesn't get us very far.
Please, Professor Solomon.
Thanks. So maybe just a small point, and that is sort of, in a way, the heart of sustainable development are the SDGs. And the SDGs are a perfect reaffirmation of the existing system. So it doesn't bode well that their inclusion in other regimes would be different. The Sustainable Development Goals expect 0.7% growth. The model for sustainable development is increasing foreign investment in in least developed countries, an open, non-discriminatory, rules-based trading system. So, within the aspects of the SDGs that speak to issues that might really be important to sustainable development, it's really about reaffirming the existing model. So if we're not doing very well on sustainable development in the core area of sustainable development, then it gives reason for some concern that it would have the kind of impact in when it's an add-on or introduced into other regimes, as I think Fabio and James have made clear.
So another question that's come in from our audience, I think, taking all of this into account, the Global South and many states that would challenge the system as it exists at the moment, many of them are still reliant on foreign investment coming into those states. And so what would be a specific way to encourage investment in developing economies without overly prioritizing the interests of capital, as the current international regime has done?
Well, I think that's going to be difficult because, another of the challenges we're facing here is the way that the international system is organized around the idea of nation states. Nation states, in my view, are captured, especially in the Global South, by elites who are more connected to the Global North than to their own constituents in their own countries. So when Fabio, says that he's surprised that the positions being taken by Global South countries in the UNCITRAL Working Group 3 process, I'm not surprised. These are the same elites that hire other elites in the first world to go represent them in international courts while ignoring people like Fabio, who would do much better representing the interests of the majority of the population of Brazil. So these are some of the structural problems in the international legal system, and in the way in which the global system really is connected through networks of those that control those states in the global south, and sort of the interests of global capital in the global north. But these are not the types of conversations we have. We tend to think that, the nation state should be in the global south, should be acting in the best interests of its population. And I think that's an assumption that is just an assumption. So, I'll leave it there.
Sorry, I think I was on mute. Professor Solomon, please.
Just a small remark that was prompted by James's comment, and that is, that speaks in many ways to the assumption that underpins all of international law, and that's, that states are democratic and they're representing the interests of their people. And once they get to the international level, that assumption is a given, right? They're all equal in the UN, and it's one state, one vote, and there's no questioning of those democratic credentials. And either, we know that democracy is being challenged in very fundamental ways in the global north and the global south. We know that, the degree of inequality undermines democracy, and we're seeing that in all sorts of ways. We're also seeing it, through forms of new technology and so forth. But and also the reasons that James have given about the way in which, historically and present, there's sort of this elite network, and we see it similarly. I gave some examples about debt, but this is a lot, an old story about states in the South that, regardless of what their intentions are beholden to their creditors, and they can't represent the interests, the democratic interests of their people. They're simply precluded from it because the nature of the conditions, preclude them from that, and they're accountable to the creditors. So they're enfeebled, right? There's this middle layer of, all sorts of different constellations and so forth, but many are enfeebled, some are captured with their, global north connections. And in some cases, democracy is just non-existent. But at the international level, none of that is considered. There's an assumption of democracy. And I think democracy is hugely weakened for a whole host of reasons across the board. And I think that's a fundamental problem that international law has. And that is the construction of international is based on this, system of negotiation and agreement between states. And those states aren't for the most part, or in many instances, credible. And that goes for the North and the South alike. So we have quite a profound problem about, the making of international law, which probably speaks back to the voices that should be heard and how we reimagine even the very making of international law from the start.
Okay, can I just add something to the discussion? I agree with what has been said about the role of global South, maybe elites in negotiating these types of agreements, and how maybe we will never move maybe in another direction that is more beneficial to not the elites in the global South, but to the global South people, right? But from my experience in meeting and talking to elite negotiators in the global South, and especially I'm talking about the case of Latin America, there is I can see, and that's my testimony, that I can see that there's like usually liberal-minded elites in the global South, that they perceive participating in negotiations, no matter the position that they're going to pursue, as being important. So they think that it's important for them to be in the room, and they feel somehow legitimized as in being in these instances. So this is something that maybe plays out in the psychology of these people, but also I think that there is a sense that investment agreements or trade agreements are just part of what modern international law is. So there is a sense that this is the way that we do, and there's no way out. And this is, how we should be doing. This is our role in the global economy. So I'm very sad to realize all this. I'm not naive, but I tend to think that some members of the elite in these countries, they may be agents of changes. But then, if I'm giving the question back to my fellow panelists. So, if the answer to change is not in the global south, because the way that the system is structured, and maybe the response is because the south is colonized, and so this and the colonization process is so deep in terms of this, and it enters the psychology of people. So it's an internal colonial, internal colonialism. Then my question is, how do we go about changing? So do you think that the institutions or actors in the global north would be keen or honest to change the way that the society and the global economy is structured?
I mean, if I may just, I'll let Professor Solomon go first.
James, go ahead. Fine, thank you.
Yeah, I mean, I think, yeah, it's not to be very depressing. I want to make 2 quick points. One, maybe we are looking at the wrong places in the global south. If we're looking to the states and the elites that are running these states, I think we will come to the point that Fabio is raising. There are really important civil society movements and grassroots movements that that have been very active on all the issues that we have discussed, and that that if they had the reins of the state, I think that things might actually, there might be more potential for movement in a different direction. So that's the first point. The second point is that I think it's important also to recognize, and I think Professor Solomon said this in her presentation, that there have been moments in the past where the third world, in quotes, really came together to try and fundamentally shift the system. And one was the debates around the new international economic order, the Charter of Economic Rights and Duties of States. Those were moments that I think were the momentum for fundamentally restructuring the way the rules had been written were there. The last point I want to make is that perhaps what we are left with is what one of the those that was involved in those struggles, the Egyptian international law jurist whose name is on my tongue and I can't say his name, who says, maybe we need to be
Abissab.
Yes, Abissab, Georges Abissab, thank you. Fighting behind the enemy lines. So we can't underestimate the importance of, as he says, which an article I really highly recommend to everybody. He presented in a 12 conference in Cairo, fighting behind the enemy lines. So I think that we shouldn't underestimate that as well.
Thanks. So I just wanted to, what came to mind listening to Fabio was this sort of perennial practice. And from, I wrote about it when I published my first or second article 20 some years ago, and I see it still being deployed today within the UN human rights bodies, where NGOs and organizations will raise issues around trade or investment or finance, and a northern state, usually this, the EU, will take the floor and say these are hugely important issues, but we don't deal with them here. We deal with them in the WTO, or we deal with them somewhere else, or we deal with them, in the IFIs. And so there's, an inability. Of course, we know that, that there are independent experts and special rapporteurs and others raising these issues, and the treaty bodies and so forth, but fundamentally addressing this within the halls of power where justice is meant to reign, i.e. the UN human rights bodies, it's still really fundamentally unwelcome, precisely because it's not in the interest of the stronger states to have those elements raised there. And moreover, as is common knowledge, they kick those issues into the institutions where they either formally or informally hold the balance of power. And that's been the case always. So we're back to sort of our point one about how we reinvent and rethink the making of international law and the integration of these issues more holistically than the impediments to that at a formal level, an institutional level.
So I think flowing from that, and this again is an assumption that I think is open to be challenged, but there is an assumption that strong protections for private property are a precursor for social and economic development. And we're seeing this play out at the moment in the calls for patent protection to be waived and for compulsory licensing to be granted for COVID-19 vaccines. And that's being weighed at the moment against concerns that pharmaceutical companies will be less likely to innovate in the future if they're not given sufficient control over their intellectual property. I would be interested to hear how our panelists think that this balance should be approached between individual economic rights and, I think the attendant expectation that those encourage innovation and development with the public interest in circumstances like the pandemic at the moment. Professor Solomon.
Okay, so I would frame it differently. I think in a way some of the problem comes from this striking this balance. I understand your language and it's perfectly reasonable, and that's in a sense what we're trying to do. But I think what ends up happening is we're discussing changes within the existing system, and what I'm sort of tirelessly advocating for within, on this panel, is to step outside those assumptions and think how we might do things differently. And it's not an area of research myself in any great degree, but even sort of on the margins, there are loads of really innovative ideas that don't require, private property or intellectual property in the way that we've organized it at all, and is incentivizing and addresses some of the longstanding issues, including around the kinds of drugs that are targeted, right? Drugs, the special rapporteur 20 years ago, Paul Hunt, wrote about, the perverse incentives, right? Where, if you're going to make money on selling drugs, you make drugs that rich people can buy, right? So the kinds of diseases that we want to target aren't being targeted. So I'm just thinking about, and again, there may be other more novel ones out there, or a wide range of them. And this goes back a few years, but there's the global, it is the health, Global Health Impact Fund, for example, where, there's a pool of money and R&D is rewarded, drugs, the production of drugs are rewarded on the basis of relieving the global, illness burden, right? And this kind of thing. So there are ways of incentivizing and reimbursing and subsidizing and so on that is not reliant on the current system that we have at all. So really sort of these questions, I'd like to see us sort of step outside existing assumptions to rethink entirely the model that we're currently, that's currently being deployed.
Yeah, just to add to that, I would say, I agree with that, and I encourage everybody to read Anne Orford's latest piece in the London Review of Books, where she says that we shouldn't regard these intellectual property rights protections as natural, necessary, and inevitable. They've just been around for the last 25 or so years, and at least at the WTO level, and we shouldn't think of them as only from the perspective of, what India and South Africa are trying to do now, which is to sort of argue for a temporary suspension. We could do away with them. Those medicines long before the TRIPS agreement came around. So I don't think that anything, in my view, is off the table. And unfortunately, the big economies are, in my view, in the pockets of big pharma. And nothing really has changed from the early part of the 21st century. I remember as a young academic sort of hearing these same debates around access to essential medicines for HIV and AIDS. The exact same arguments And you know, now we have a democratic administration in Washington, but even they are not go for the suspension of IP rights because of the power of the IP lobby, and just the way things are. And I think they have to be stated that way. It's not about the inevitability of intellectual property rights. It's about the power that lies behind those interests that support that regime of rights.
Yeah, I agree, and I think it's also how these types of concerns are inserted or not within the existing system. And I agree with Professor Solomon in the sense that we should be more creative and innovative in thinking about alternatives, even alternatives that, in the language of the capital, creates incentives for these innovations. So I do think that the problem lies on where these types of concerns are structured within the existing system, because given when we have it as a waiver, so a public health waiver, or exceptions to public health and so forth, I think the margin of change, or the margin of or even winning an argument on those bases is really minimum. So it's we're back to the discussion on exceptions, and I think it should the logic should be changed, especially now that for this generation we're facing this tremendous health crisis. There's got to be space for a more for a different way of approaching it within the international economic system.
Now, to end on a slightly lighter note, many people that have seen the promotional material for our series, for this panel and for the other panels that we've had, have really commented quite starkly that our panels have looked very different from the panels that they usually see at international law events. To what extent do you all think, and I know you've touched on this at various points in your presentations, but do you think greater diversity in backgrounds and origins of practitioners in international economic law is having an impact on the development of the law itself, if at all? And I think this is, ties in somewhat to the idea that you may have people that have a diverse background, for example, from the global south, but that in and of itself is not necessarily creating the change, and in some instances may just be perpetuating the same system.
Should I start?
Please feel free.
Okay, I think this touches on a very hot topic, which is the political economy of knowledge, right? So who gets to say what is important and not? And that in the end of the day, that's the story of international law, right? International law, as Marty Koskiniemi says, is whatever international lawyers says it is. So as long as we have the same people in the room, and that's for academia, and that's also for practitioners and negotiating rooms, we'll have the same type of rules. And I do think that, so going back to the point on the global south, I think the challenge is really to have a more inclusive debate about these issues that go beyond the official negotiators, and how civil society can be more active, and also how countries in the global south can embrace the ideas of civil society, because it's not as if civil society is not there and it's not very active in Brazil. It is very active, but how can you make this liaison, this transition from a wider public in the global south to the positions that those states represent internationally? And I know that from an experience I had with the Brazilian tires case back in the early 2000s. And I remember we had meetings with the diplomatic representations of Brazil, and the room was full with civil society people, and they wanted to have their voices heard. And the Brazilian diplomatic mission was not very open to that. So and they say, okay, you can petition by yourself, right? So I think that the way that we reach or build positions in countries, and I don't think that's even in the global south, but maybe here I'm being very utopic. I think needs to be much more inclusive.
If I could push you a little bit on that, in that scenario then, where we have civil society that is present but is not being heard, and we have states that are not willing to listen to civil society, who do you think is more likely to be the site of change? Is it that we should be encouraging states in some way to change their practice, or do you think that it's that we should be telling civil society, you need to be even louder and more assertive in what you're doing?
Yeah, I wouldn't, I mean, from my experience, I wouldn't expect that states would change. And I think it needs to come from, from this resistant voice, the resistance voice from the civil society, and creating, new spaces for debate and finding ways to influence international politics, despite the states.
Professor Sullivan.
Yeah, so yes, needless to say, diversity and voice is hugely important. I think what we need to always sort of be aware of are the lessons that have come from, feminist approaches and feminist movements, including in the area of international law, where there's a risk, and it was one of the critiques that came out of sort of the Beijing World Conference on Women and stuff, that there's a risk that you bring people on board, different voices on board, and it sort of add different voice and stir, right? So you add them to an existing conversation, and you don't situate them to be change makers. You situate them to add a certain degree of input to an existing system, an existing economy, an existing model, an existing political system. So participation is extremely important, but we have to be cognizant of the risk of co-optation, the risk of a tick box exercise, and consider whether those voices add legitimacy to an illegitimate system, or whether they're situated in a way in which they can affect meaningful change. So it's not at all costs, but certainly, of course, those diverse voices are extremely important. And there are people writing on, and there are in the food area too. And again, I'll mention Michael Fakhri's report only because he sort of looked into this a bit, and he refers to a number of other scholars who are working in this area precisely about how international institutions have taken on board diverse voices and structure their discussions and negotiations in far more open and plural ways than we've seen so far in, for example, in the UN, where it's a very sort of formal sense and a formal way of contributing that the NGOs have, and still relatively limited. So some of those initiatives are taking place, in the halls of relative power.
And just to add to that, I think we could all agree. I think we all agree that inclusion and participation and diversity is the weakest critique one can have of international economic law, for all the reasons that we have seen. I think that what we have seen in international economic law, from the era of the Drago Doctrine or the Calvo Doctrine to the era of the New International Economic Order to date, is the systematic exclusion of more radical voices. And I think that's the trajectory that's more interesting to me, the systematic exclusion and silencing, not only of those voices, but certain issues that, like race, that are embedded within the very structures and doctrines of international economic law. It didn't matter whether it was in the sort of early 20th century when Latin American states were campaigning against gun diplomacy, or the post-colonial moment after the Second World War, or the debt crisis moment that Professor Solomon talked quite eloquently about, especially in Africa, where we had civil society groups, especially women, that were really opposed to structural adjustment programs. There's a lot of political energy in opposition to and providing alternative visions, but it's invisible. And I think the challenge for international economic lawyers, in my view, is not to operate within the givens of the discipline, but to, in my view, depart from and critique and challenge and overcome the given assumptions of the discipline and expose all these silencing and exclusions.
So we did promise to our panelists that we would keep the session to an hour and a half, so we will unfortunately have to end our discussion there. But I would like to thank each of our panelists for giving us a lot to think about and bringing each of their unique perspectives to our discussion today. And of course, a huge thank you to our audience for attending and for their participation through the Q&A. This was session number 5 in our ongoing series on reconceptualizing international law. And our last session, session 6, will be taking place next month. We'll be distributing details for that shortly. But thank you again, and we look forward to continuing this discussion offline.
Thank you.
Thank you.